2, 1. We're live, people. We're live, and what a day. Who would have ever thunk you would have 113,000 people watching a live stream of a trial with live commentary by a panel of lawyers, an invoice of lawyers? Who would have ever thought that justice and law itself would acquire? I think we're at mainstream levels of interest. I mean, when Ricada has more people watching than PBS, when Crowder and Ricada combined have more than PBS, Fox News combined, we are, let me just turn that off. We are reaching mainstream levels of interest in the law and the transparency that doesn't just entail, but that it imposes on the process itself. Hundreds of thousands of people are watching this. I think Ricada's stream yesterday, which, if you can imagine, was 9 hours of nothing because it was deliberations yesterday with minimal actual aspects of legal interest. That stream yesterday has 1 million plus views now. That is 1 million, assuming how it works. I'm assuming it's a million, what do they call them? Distinct users or whatever, even if it's less. 1 million people have now watched this trial through a stream of lawyers talking about the trial when nothing was actually happening in the trial itself. Volume too low. Okay, hold up. How long has that been going on for, people? You see what happens? How do why can I not adjust my own volume? And why is my dog eating something behind me? Audio. Oh, there we go. Okay, sorry, peeps. Here we go. Let's bring it up to 60. Yeah, I'll bring it to 75, a nice round number. All right, sorry about that. 1 million people. What are you eating? What are you eating? Don't eat that. Okay, dog's eating paper. Okay, well, tell me if the volume is too high. This is hard evidence that he was eating paper. What were you doing? I see. Go back and do it. 1 million people watched a stream of lawyers talking about the legal process, and it's a thing of beauty. And today, no, that's going to get too annoying. Sorry, give me that. And today, there was some serious stuff happening. Serious stuff. We were scheduled to have a sidebar with George Gammon, and the problem is it would not be fair to a sidebar guest to try and host a sidebar today when this is going on. I mean, it would be like going to a Rage Against the Machine concert and trying to get somebody to listen to the latest Angels and Airways release. Both amazing bands, but one is going on right now, and people need clarity on it. So let's do first things first. A couple of chats so I don't have to... Shinobi Assault says, I don't have a lot of funds and I super chat spam on group stream without being read. Can you guys please try to contact any of Death to help Kyle? Well, look, you can't. Lawyers cannot reach out to represented clients. It's not clear who is contacting with Kyle, whatever. But I think some of the information online is making its way through to the team over in due course. Viva, do you know if OJ or Zimmerman trial attracted this much interest? I mean, I don't know. I don't know how you measured it back in the day. And they didn't air it 24, they didn't air the entire thing. Maybe they did air it the entire day and you would tune in and out of it. I lived through the OJ trial, but I was 13 years old, maybe 14. I remember people waiting on the verdict, but I don't remember people watching the day in and day out of it because, man, I just can't imagine that there was this level of interest in the OJ trial, although it must have been, the most watched trial at the time. Zimmerman, no. Zimmerman, even I was relatively conscious at the time and didn't even know that if they were broadcasting it live the way they're doing now, but there was definitely not this level of interest in Zimmerman, but this is a level of interest that is gaining its own momentum, and it's becoming like gravity. The bigger it gets, the more it attracts quicker because the more people it's reaching and spreading out to. Now he's eating. What are you doing? Stop it. So but it's glorious to watch. It's glorious to watch because there are people now who realize you can get, maybe it's not totally neutral because I think right now we all have our opinions on the matter. I don't think any of our opinions are affected by our politics, and we are not propagandist entities because we are subject to the scrutiny, the relentless scrutiny of our viewers. We are definitely independent and more objective assessments than what you get on WAPO, MSNBC, NPR, and whatever. David Hartman says, Viva, your videos are informative, interesting. You make the most detailed minutia of the law exciting because I understand it more. Thank you very much. I put out a vlog today on the motion to dismiss with prejudice based on the information that was available when I made it this morning, information which evolved throughout the day. We're going to talk about it tonight. F for Viva sound levels, but he fixed it. Thank you. And by the way, like a boss. Now I dropped my lips. So this is okay. So standard disclaimers. YouTube takes 30% to super chats. So if that bothers you, and I can understand it might bother some, you could support us on Rumble, where we are simultaneously streaming. Rumble has what they call Rumble Rants, which is basically a super chat, except Rumble only takes 20%. And you could feel better supporting a company like Rumble, which is more free speech oriented and less censorship driven. You know, like taking down a stream through some internal glitch while the stream was on its way to gaining 100,000 viewers. Recadas on Monday. And another amazing thing actually about Rumble, I am not sponsored by Rumble. I just like the platform and I like the company. I'm not sponsored by Locals, but we have a page on Locals, vivabarneslaw.locals.com, which Barnes is going to say a couple times as we get going. Subsequent to their merger now, and I think my channel on Rumble is the first one to have this option, that there's a direct link to Locals via my Rumble account. So, I mean, facilitates finding us through Rumble. It facilitates supporting us on Rumble if that's what you want to do. But it's the trial and it's the integration of the two websites now, and we're going to see how it works. Did someone just say volume not great? Volume not great. Make it higher. Can you make it? Well, I'll wait until Barnes gets in and we'll see how this goes. Okay. So that's it for the super chats. I'm going to try to bring them up, but we're at this insane level where I can't bring them up. And if you're going to be miffed, if I don't bring up your super chat, don't do it. I don't like people feeling miffed, grifted, show whatever it is. No legal advice, no medical advice, no undermining election fortification advice. And with that said, let's get this started because we got what to talk about tonight. Robert, how goes the battle?
Good.
Okay, now let's just let the chat tell us if our respective audio levels are good compared to one another.
All right.
All right, audience. You've had your chance in the audience. Okay, let's see if we get some comments in there. Robert, where do we start? Where do we start with summarizing the day? Now, I take for granted there's going to be some overlap with Recada's stream, but then I also take for granted there's a lot of people who don't have 8 hours to watch a day-long stream of the trial. So, I mean, let's start, I guess, with the initial news of the day before the developing news. The defense filed a motion to dismiss, sorry, not a motion to dismiss, a motion for mistrial with prejudice. Anyone who watched the video knows what that is, but explain to the crowd what is a motion for mistrial with prejudice.
Yeah, so I mean, they ended up filing both. They did a written motion for mistrial with prejudice. Later in the day, they moved orally for a motion for mistrial without prejudice. So the difference between the two is a mistrial with prejudice, any dismissal with prejudice, whether it's labeled a mistrial or a dismissal, is bars subsequent prosecution because it violates double jeopardy. A mistrial without prejudice does not violate double jeopardy and allows the state to retry the case.
Now, as far as I understood, or I think I learned today, there can be a mistrial without prejudice, meaning Kyle can be retried, but certain limitations on a new trial can be placed by the judge, or is that not possible at all?
Not really, no.
And then could you have dismissal on certain charges with prejudice, but not on others? Could you have a partial mistrial with prejudice?
The judge even suggested that it was possible to declare a mistrial with, or, well, he was even suggesting mistrial without prejudice to some charges and not to all. And the idea being that I don't think the judge is fully fleshed out, that the provocation theory was applied to all of the charges, even though the provocation purportedly only happened to Rosenbaum. Because if Kyle does not have self-defense as to Rosenbaum, then there's less clarity as there's self-defense as to other individuals, other attackers. And so that the judge never really fleshed that out. And honestly, the jury instructions don't really flesh that out. So but the judge seemed to assume that if the mistrial was about the video evidence, the drone video evidence and the quality thereof not being produced to the defense, that would only apply to the Rosenbaum charge. And it's like, no, it would apply to all of them because he didn't limit his provocation instruction to just the Rosenbaum charge. So as Dershowitz noted, this was not the best given jury instructions ever given by a long mile.
You know what? Remind me to get back to some jury instructions questions, because we studied in law school, but I've never worked with a jury because we don't have civil matters that are judged by jury anymore in Canada, and I've never done criminal. But remind me to
None
get back
at all?
for civil, none at all. And I've never done criminal with a jury. I wanted to sit on the jury. Like, I got jury notice. I was like, booyah, I'm going to do this. Then I checked the back of it and it said lawyers can't actually be jury members. So I was kicked off. Yep, I was kicked off before I could even be on, and I wanted to be on. The motion to dismiss, the motion for mistrial itself, I mean, I presume you read it. It was relatively short.
The written one, yeah.
Yeah. Was that the first motion for a retrial that was filed in this case in writing?
I guess so. It appears so.
And it's easy to be critical, and I'll be critical to some extent, drafting stylistically. Substantively, what did you think about that motion for mistrial?
Glad they filed it. Could have been much better.
Can they amend it to add more substantive allegations to flesh it out as they wish, or do they have a certain limitation on how many times they can amend?
No, they can keep moving for mistrial until the jury returns a verdict. And then afterwards they can ask for a new trial on the same grounds they asked for a mistrial. The appellate difference is a motion for mistrial with prejudice granted while jeopardy is outstanding before the jury has returned a verdict. There's arguments about whether that should be or is appealable. In the federal system, if a judge grants a mistrial with prejudice or a directed verdict after jeopardy is attached, after the jury has been impaneled, but before a verdict is returned, is not appealable. It's not clear whether that's appealable or should be in Wisconsin. But if you grant the motion for mistrial either with or without prejudice after the jury verdict has come in, or after the jury has been hung and a mistrial declared for that reason, that is a fully appealable. And so then you're at risk of an appellate court reversing and reinstating the case. That's happened before in Wisconsin.
All right, let's just see this here. Why does... I'm not making those jokes, people. Okay, so the motion for mistrial, they raised the obvious examples that we've seen for those who have been watching or have not been watching. At one point, Binger fundamentally violated one of the most basic rules, the Fifth Amendment right to remain silent, by questioning Kyle in front of the jury on his silence, leading to having viewed all of the witnesses during the trial and then speaking for the first time. The judge kicked the jury out of the room and admonished Binger, who then, 2 minutes later, 5 minutes later, whatever, when the jury came back in, then proceeded to ask Kyle questions on evidence that the judge had ruled would not be admissible. The other acts evidence of what Kyle allegedly said in his car. Don't even need to get into it. So he had those two immediate. One was a constitutional violation. One was a violation of a court order that said you're not asking any questions on the other acts evidence. And Binger goes and does it in front of the jury without asking for permission, resubmitting whatever. And the judge said, if you're not over the line, you're close to it. What were the other violations that Binger did? Oh, then the big new issue is the disclosure of this, the drone footage or the higher quality video that was in the possession of the prosecution, but they didn't communicate it to the defendants. So not only did they communicate certain evidence late in the game, magically discovered evidence that was submitted to them by an unnamed individual who showed up to the police station to give them this drone footage. So we don't know the provenance of the drone footage itself, which we'll get into. But they then communicate it in a tardy manner to the defendants after evidence is closed. Basically, they've given them this low quality version of this footage, which they are now effectively relying on for the provocation response to the self-defense privilege. So those are the three elements as of today for the motion for a mistrial. What does the judge do time-wise? Because the jury's deliberating now. What is the judge waiting on? And if he sets a time frame for a response from the prosecution, unless deliberations take 2 weeks to a month, he's going to, he's going to run out the clock through the jury before he adjudicates on the motion to dismiss. No?
Yeah, and he made clear that's what he's going to do anyway.
Okay, so the motion for mistrial, they can amend it and add details. Do we know what the time frame is for the prosecution to respond?
Judge didn't give any.
Okay, and you look a little irritated, Robert. I mean, what's your feeling on what's happening, and especially the developments of today?
Sure. So, I mean, my view is this is the product of poor jury selection, failing to do jury selection, and that was predictable before trial, and that reflects 3 or 4 rogue runaway jurors being on the jury, holding up the jury from acquitting. I think that a random jury, that's what a random jury in Kenosha produced. It produced a mistrial. That's what I mean, we were the only ones, to my knowledge, to poll the Kenosha community. Richard Barris, People's Pundit Daily, polled it extensively to figure out what was the mindset and mentality of jurors in Kenosha. What were the indicias you could use to determine whether they presumed Kyle guilty or not? By law, you have to presume a defendant innocent. So anybody presumed him guilty should not be on the jury. But you need to do probing voir dire, probing jury selection. Not only you get their names and information a week in advance in this case, and so you can do a full deep dive on their social media, find out everything about them. There were certain demographic associations. There were certain political affiliations associated with being biased and presuming Kyle guilty, and then certain beliefs and certain life experiences and certain attitudinal biases and certain reliance on certain media sources. And to my knowledge, most of that was not inquired into at all in jury selection. And it's apparent they didn't do any meaningful deep dive at all on data, even though it was made freely and fully available to them. And that was their choice. I heard some people think it's Kyle's choice. He's 18 years old. He has no idea how jury selection works. He's going to defer to his lead defense lawyers, Mark Richards, and it was Mark Richards who said no. And not only said no, he said he wouldn't allow anyone to even know, to even be able to help, to even be able to contribute at all. Can't come into the courtroom during jury selection. Won't allow you to even know the names to look them up and tell us what you have. That's what he did, and that was legal malpractice in my view. It's been a slow awakening in the court system. They think juries, a lot of judges, pick juries by roll the dice effectively, and they assume prejudice doesn't exist. That this is not the modern world anymore. The social media. I mean, this became clear in the Chauvin case. I said before the Chauvin case, I didn't think historically there's at least some jurors who have not been exposed to pretrial prejudice, even in high-profile cases. Social media has changed that. Everybody now has been impacted. Everybody, every single juror raised their hand. Apparently, according to what we heard and listened to and saw, when the judge asked whether they knew about the case, had heard about the case, had seen video about the case, and again, the video they'd seen was misleading video, media video. So and then there were certain ancestral backgrounds, certain socioeconomic backgrounds, that just what it all corresponds to is if you trust the institutional media, you were prejudiced against Kyle. Not only that, their prejudice was intense and deeply held. It was prejudice that you were not going to budge in jury trial. And there was a lot of naivete by the defense team about that. And even when they were given data and information, they ignored it. Not only that, one of the great concerns was we found about 80% of Kenoshan jurors were concerned that if they were on the jury, that what the outcome would be if they voted for acquittals. And, that's a problem. That's a problem that has to be dealt with in jury selection. Frankly, it's a group that should never be on the jury.
I mean, I was going to ask Robert.
Impacted by that.
I was going to ask if they even asked that question, but given the duration of jury selection, I'm taking for granted that specific question was, if asked, barely fleshed out at all.
Yeah, I mean, jurors volunteered the information is what happened, and then there was pushback against them volunteering that information. So, in other words, saying that shouldn't be a problem, and that's why we're here. So Kyle's is, I think, put unnecessarily and needlessly at risk by lawyers who decided not to do real jury selection. Now, the second mistake, in my view, was not prepping the judge for this fact, because I think that the reason why the judge thinks an acquittal will bail him out of any consequential decision in political controversy. What happens if there are convictions? Does anybody think this judge is going to step up to the plate then and now dismiss?
So here,
That's at risk now.
and people were saying, the judge is saving it to save Kyle. It's a win-win. If the jury acquits, then the judge doesn't have to make a hard decision. If the jury convicts, then the judge can save Kyle. But by virtue of the fact that the judge is holding off intervening in any way whatsoever with the outcome, do you think the judge is going to effectively overturn an outcome of conviction by granting the mistrial with prejudice or without prejudice? Maybe without prejudice, especially if this external and clearly visible pressure on the jury and the courthouse itself could be argued to have an impact. But yeah, I mean, I think you made that point during Recaita's stream today. Far more likely that the judge is trying to not save his own butt in a cynical sense, but just not make a decision, hope for an acquittal. But if there's a conviction, he's not going to necessarily be inclined to intervene.
You can't trust that at all. You can't trust that at all. Because again, and now if this judge knew about the pretrial prejudice and its impact on the jury, then he would be more eager to step in now, because he's hoping an acquittal saves him. He's assuming a conviction can't happen. And in part, I think, because of his own opinions about the case. And in part, I believe, because the defense lawyers, that's what they've been signaling to him. They didn't scream for extensive jury selection. They didn't ask a lot of questions during jury selection themselves. They didn't tell him at all about how much the pretrial prejudice had hurt the jury pool. In fact, their behavior had been quite the opposite direction. And so, this judge could be sitting there saying, there's a few holdouts. They'll fold, no problem. I won't ever have to face this.
Well,
That's the problem.
Do you get the impression, like I say, strategic mistakes are that this judge continually or repeatedly references reading the news, and he responds in the court to what he's reading in the news, which I think is a mistake in and of itself. But to me, it also is an indication that this is the first time he's received such public scrutiny or, commentary from the media during a trial, because I don't know that he appreciated it would be this high profile a case. I don't think anybody ever appreciated you'd have 100,000 people watching this live on the internet. But I don't think he fully appreciated that at any point. And now he's seeing, you call it scrutiny, call it evisceration from a media that has decided he's not necessarily an ally anymore. And he seems to be unable to deal with it. But it's putting him in a position now where he's either afraid or reluctant to intervene in any meaningful way because of the continued evisceration he would get by a media that will accuse him of bias in intervening.
Right. And that's the problem. I think that he may grant a mistrial without prejudice if the jury hangs. He may, and so that option's still on the table. But because they didn't push hard enough, the other things like how to file, I've filed mistrial motions before, and they're broad, long, and extensive, and detailed. And so, you cite the law, you find analogous cases where other courts have done what you're requesting they do on comparable facts, and then you cite all of the evidence. I mean, it's not just what he's done in parts of the issues they cite. The prosecutor is also, he's been lying about Kyle and created the pretrial prejudice with defamatory statements using the cover of courtroom privilege to make the false statements in the guise of bail issues, in the guise of evidence issues, in the guise of pretrial issues. That was level one of his misconduct. Level two is withholding documents, withholding information, delaying disclosure of information all the way through, including the FBI video and the HD video of the FBI that magically went missing, that purportedly didn't know how it went missing. Then during trial, it came out that he had attempted to suborn perjury. I believe he did suborn perjury with certain witness testimony, that he had effectively obstructed justice, in my view, his manipulation of criminal charges of other co-defendants, hid the fact that he knew who Jump Kick Man was, that kept Jump Kick Man from testifying effectively by not granting him immunity and having criminal charges stay outstanding against him without disclosing the information and the details about Jump Kick Man. And then engaged in Fifth Amendment violations and clear pretrial court orders during his cross-examination of Kyle, on top of making repeated misstatements of fact or misstatements of law, both in his opening statement and particularly and perniciously in his closing argument. And then now this last piece of evidence that they withheld critical, essential material evidence appeared to have doctored the timeline to make it look like they weren't responsible or accountable for this for the failure to produce the HD version of the video. And so it's just been item after item after item after item. But because Richards didn't want anything negative said about Binger before trial, didn't want investigations into Binger before trial, didn't want any of that revealed in the court of public opinion or the courts of law, is partially why we're here. I mean, Kyle is at risk solely due to the failures of his defense team, which is in part the product of, David Hancock, the security guy who's basically hijacked the defense.
I want to come back to so many things you mentioned. I'm just going to bring this up. Is CCAP wrong stating Richards filed motion with prejudice? The mistrial with prejudice?
They filed it on Monday. That is correct.
Yeah, so
November 15th.
CCAP, I have to just get
It's the Circuit Court Access Program of Wisconsin.
It's no longer called that. Apparently, that's the older term, but whatever. That's where you find the filings. The written motion for mistrial that was filed is with prejudice, which brings me to the question now, Robert. Today, Shira Fisi in court volunteers for a motion for mistrial without prejudice. My question at the time watching this, does this trump the motion for mistrial with prejudice that they filed? Is he effectively renouncing to that aspect of the motion with this verbal motion? If not, okay, but then why on earth does he soften his position in what he's pursuing to go after a motion for mistrial without prejudice, which in theory, I presume, had Krause accepted at the time, they could have accepted. He could have accepted on the bench right there, and then it would have been a mistrial without prejudice.
Yes, that's correct.
Okay, so I'm thinking Krause just blew it by not accepting that offer. I would have done that in a heartbeat if I were the prosecution. But why did he do it? Why did he do it?
We don't know. And so how usually that's interpreted is two different ways. A judge may interpret that you're just preserving appellate review, that you don't really want it to be granted, but you want it to be on paper so that if something goes sideways, they have an additional appellate issue. The other possibilities the judge saw it. I do think that's the way the judge saw it. The other possibility is that he really wanted the mistrial, and usually that's interpreted as the defense thinking they're going to get an adverse verdict. That's usually the assumption. The prosecutor not going along with it suggests the prosecutor thinks now they could get a verdict in their favor. So I think they're both misreading the jury. My view is that it's still more that convictions are still very unlikely on any of the top three counts, any homicide count. And reckless endangerment doesn't likely pose major sentencing risk given most people's interpretations on the ground, including longstanding journalists in the area, of the court's predilections on this case for sentencing on reckless endangerment. But that would be the common interpretation, is that you as a defense lawyer only ask for a mistrial without prejudice if you think the jury is likely to rule against you. You never ask for it if you think the jury is about to rule your way.
I mean, I just let the jokes begin. I could not believe he made the offer, because if I'm the prosecution, well, first of all, I'm a cynical man now. I think I might have taken a black pill, Robert. I'm thinking if I'm Shira Fisi and Richards, and I don't think that Rittenhouse has the finances for a retrial, no way do I ever pursue that as an option. I would accept it as the worst outcome, but I would pursue with prejudice, tooth and nail. Part of me feels like they might look at Kyle Rittenhouse like something of an ATM, knowing that, hey, so many people are now emotionally invested in this. If it's a retrial without prejudice or a mistrial without prejudice, we'll be able to raise $1 million for a second trial. Why not? If I'm the prosecution, I'm saying, I don't know how they refused it. I would have accepted it on the spot. We'll learn from our mistakes. We'll soften some of our strategic mistakes. We'll pad some more of the witnesses to fill in the gaps of our weaknesses. I would have accepted it on the spot. To me, it sent like throwing Kyle under the bus in the worst kind of way, because if they accept a mistrial without prejudice, they've got to go through this again with all the costs that incurs. And if he doesn't have the money, I wonder if they make that offer. Well, actually, first of all, what do you think of that?
I don't know. I mean, my read on that is that, there is always an issue with the way defense fee structures are structured, that I think the ethics rules should be changed so that you can allow bonuses and contingency of criminal cases, because I think it changed the incentive structure to more align with your duties as defense counsel to be zealous advocates for your client. Right now, the way a lot of defense fees are handled, that doesn't always happen. I'm not a fan of hourly billing in defense cases for this reason. I always recommend a flat fee. And the reason why I recommend a flat, I've had this debate with the Wisconsin actual director of Office of Lawyer Regulation, who was trying to ban flat fees and was trying to limit them and then try to make sure they're refundable. Refundable flat fees can basically make it an hourly billing case. That's the problem. And had this debate with him in front of the Wisconsin Supreme Court, no less, about 10 years ago. Supreme Court mostly sided with my position. He wasn't happy about that. That didn't lead to cordial relations for a while. But he came around over time. The not on that issue, but in terms of our dynamics. But the nature of it is such that that always creates a risk. So, like you should have a fee structure where it incentivizes you to be a zealous advocate for your client, not where it incentivizes you to prolong or protract criminal proceedings. And the current fee structures that are commonly provided for defense lawyers, often due to ethical limitations by state bars or Supreme Courts of those states, ultimately, in my view, distorts the incentive structure. And so I've never been a fan of that. And so that's part of, you can't ignore that possibility because of the distorted incentive structure that's created by the state ethical rules in part. But my read on it is that they recognize now they made a major mistake in jury selection, and that and they're panicking in response to it, is my read.
Actually, and you did say something quite insightful during the stream with Ricada, that they might have sold this to Rittenhouse as being, if they don't come back with an acquittal in 2 hours, you're in. Or they might have created the expectation that they're going to come back with an acquittal in 2 hours, and when it gets into now 2 days or a day and a half or a day, by the time they made that request for a mistrial without prejudice, they're panicking and they're saying, "Holy cows!" Rittenhouse is saying, "Why haven't they rendered an acquittal yet?" And he thinks he's in big trouble, so they all start panicking because of the expectations they set with Rittenhouse.
Correct.
So I mean,
and I had this battle throughout. David Hancock, who's the security guy, again, not a lawyer, who really, in my view, has effectively run and co-opted and hijacked the entire defense of Kyle. Now he's running around pretending, being the spokesperson, terrible spokesperson. For Kyle, trying to find a camera to get in front of when he's ill-equipped for that task as well, just substantively and stylistically speaking, which he once acknowledged, but now obviously he's gone the other way. It was hard for me to convince people that, okay, Kyle was at risk. And, that's why I spent the money out of my own pocket. Didn't come out of any of Kyle's defense fund money. I paid for it personally to do detailed jury selection. Not only that, talk to a wide range of people who talk to a wide range of voices. Like, it was fun on Ricada's live stream. We talked to the quartering, Jeremy, who's from the suburbs of Milwaukee and knows the area, and his feedback. And what is if you lived in a certain part of Wisconsin or a certain part of the country, or within a certain political sphere, then you could not understand how it was possible that anyone could want to convict Kyle. But the reality was, most people, the majority of people still to this day, rely on institutional media. And so now a good portion of them were persuadable with the actual facts, but a good percentage were not. And that failure to appreciate that has been a constant problem. And even when I got the polling data that proved there was a problem, it was a different form of bias. There was a refusal to acknowledge that the poll could possibly be true. That just can't be true. It can't be true that anyone has such strong prejudice they'll convict regardless of the evidence.
It's amazing, because I went to a store. I don't even want to disclose which store because it might identify an employee. I was talking with an employee, and Canadian, follows CBC, CTV, maybe CNN. When I mentioned the Rittenhouse trial, and immediate reaction was, "Oh, the kid who, the crazy kid who showed up with a gun and killed some people." And man, and when you realize that you can't even really, from an independent content creator, you can't even put out a video that has an image of Grosskreutz with that unlawful object in his hand. You can't put out a video now with Binger doing what I am now thoroughly convinced was an intimidation tactic on the jury. And so you have you disincentivize any independent reporting on the, I'll call it the truth, but we'll call it the alternate reality. And you have nothing but mainstream media running literal lie after lie, literal, like PolitiFact still maintaining their fact check false. It was not clearly legal for Kyle to be in possession of that firearm. And I mean, this is the vast majority of people, and I've now grown to say it without judgment because people are just too busy. They need the syrup. They don't have time to tap the tree, get the liquid, boil it down, and create the syrup on their own. And you got a lot of people fabricating the syrup here. You got some people selling corn syrup as maple syrup. But so it's amazing, and I've seen it firsthand, and I see it in Canada, even with friends and family who still think Kyle Rittenhouse is 1,000% guilty and don't even know that another individual was there, armed, locked, and loaded, I guess is the term, ready to do what he wanted to do with Kyle, but never got the opportunity.
And then you have that compounded. And again, this is where pretrial prejudice would have helped educate the jury. I mean, would educate the court about the jury. Is you had this situation where people are continuing to protest so loudly with megaphones right outside the courthouse that they're basically getting to illicitly influence the jury during deliberations. And apparently today they had to arrest people outside the courthouse because they were behaving in such a violent and disruptive manner. So, like they should have blocked off the courthouse and access to the courthouse for several blocks, as they do in all high profile cases. This is because this judge didn't know how bad it was. He didn't know the intensity was still present. He didn't know how pervasive it was. And he has been and this is where him being on the bench so long hurts. 20 years ago, even a high profile case would have half the jury pool have no idea what you're talking about. Would not have massive protest outside the courthouse. Would not have disruptive, disorderly protests of people trying to interfere with the jury during the trial. So that's why this judge looked back at that history and thought, oh, this case won't be that risk. But that is precisely what is happening now because of we live in a world of social media. And, once you live in that world, the world has changed. Everybody hears about a case. This case was too intense for large portions of the population. The prejudice was too pervasive. And like I said, we found Kenosha, almost 2/3 of jurors presumed him guilty. That means that, you're going to have a half of them who are locked into their position based on what the questions we asked. That means a random jury would predict 3 to 4 hostile jurors that are rogue runaway jurors. And what happens if they're leader personalities? Like what happens if they're an older woman, maternal professor that's from the old Yankee aristocracy that's used to running Kenosha? Going back generations of distorting influence on misappropriating political and economic capital to themselves from a largely immigrant community, which is the history of Kenosha. You go back to the 20s. It was a lot worse in the 20s, 30s, and 40s than it is today in that dynamic, but it's still that vestigial influence is still present. Just look at who's sitting on bank board presidents and things like that. There are ways you can figure this out. And this is where doing a deep dive of Kenosha's whole history to know the underlying political dynamics, know the ancestral ties, affiliation ties, associational ties, to know, okay, this person's life experience, this person's profile, this person's connections mean they're likely to take this perspective on this particular case. I don't think that was ever done by the defense in this case because they rejected everybody who was willing to come to the table and volunteer that information and advice. And that's where the risk is. And I think it flows over on the court because the court assumes he can get acquittals. And so he's like, hey, I can just wipe my hands of this and nobody can blame me for it. And not only that, if you would have emphasized pretrial prejudice, the judge would have filtered through media coverage differently. He's almost acting like he really thought there was going to be unbiased media coverage during trial. There were too many lies told by the press. There are too many press members that can be sued for libel if the full acquittals come back. So they were going to double down and triple down on their lies and libels, and they were going to attack anyone who questioned or contested their narrative because their narrative were full of lies and libels. The Joe Scarboroughs of the world can't help but lie and lie repeatedly about a kid. LeBron James, LeBitch James can't help but do the same thing. And so this needed to be highlighted to the court that this is nothing more. The mob tried to lynch him that night, and now they want a jury to lynch him in court. And they want the court to help do it by facilitating prosecutorial misconduct and malfeasance and covering up for it and capitulating to it. And if you framed it that way, I think the judge would be more attentive and sensitive to what a lot of people are witnessing, which is extraordinary prosecutorial misconduct on national TV.
You say it, but it's the type of thing where I don't even think you could have forewarned the judge and made him appreciate it. I'll go back to the analogy of kids. You can warn parents or people what it's like to have kids, and they can never understand it until they do. I don't think you could have ever sensitized this judge to these types of things, because it's you're right. Like he's now reading the news like, but I'm the good guy. Why are they turning on me? They're turning on him precisely because they no longer view him as an ally, and he doesn't understand it, and it's perturbing him. He's been on the bench for 40 years, I think, and he doesn't know how to deal with it.
44 years.
Now, one thing because we got to go way back to what you listed a bunch of things which evidence the prosecutorial misconduct, which I don't think very many people appreciate here. Starting with Jump Kick Man, by the way, because Jump Kick Man, new information is coming out about Jump Kick Man. First and foremost of which is his identity. Allegedly, you can Google it. I don't know which news outlet it was. Allegedly identified Jump Kick Man. The only problem now is it appears that Jump Kick Man was known to the prosecution, although I believe, and I may be wrong, that the prosecution warranted to the court that they were unable to identify and locate Jump Kick Man. And what seems to be the case as of now, could be wrong, could be incomplete, inaccurate. Jump Kick Man has an extensive criminal history, said he would be ready to testify if the prosecution would give him immunity on pending charges against him for whatever, it doesn't really matter. They said no, which, they can twist if this comes out as true in any event as being, look, we're so transparent, we weren't going to give immunity to any criminal, but they didn't give immunity, which effectively means that Jump Kick Man could not be compelled to testify, I presume for self-incriminating reasons, whatever
Well,
it is.
one caveat. My view of the proper protocol is when the person that's asserting the fifth is not the defendant, then you can comment on that fact and you can put him on the stand. And he can just assert the fifth, but he can do it in front of the jury. This same controversy came up, remember, in Chauvin, where the question was, should they have been allowed to put that person who's going to take the fifth on the stand so the jury could hear the questions? This actually came up in the OJ case because Mark Furman ultimately took the fifth, and F. Lee Bailey wanted to ask the questions of him in front of the jury and let him take the fifth. And so the evidence doesn't come in, but the jury hears the questions and they know that they can make their reasonable inferences, because you're allowed to make adverse inferences from the assertion of the fifth when it's not the defendant themselves in the court proceedings.
Okay. And even if that were the only issue, that would already be relevant. Bottom line, it seems, based on the information we understand to be accurate as of now, that the prosecution lied or misled the court when they said they did not know who Jump Kick Man was, couldn't find him. So even if it's true that there was a strategic reason for which they did not give him immunity on certain charges so that he would be more difficult to be compelled as a witness, apparently they lied about knowing who he was, which made it impossible to call him as a witness, but they misled the court, which would be one thing. Oh, tabarnouche, I forgot the other one. Robert, what was the other thing that Huber. Sorry, not Huber. Zeminski. The filing of the charges against Zeminski. Now, we've heard Binger talk about evidence of his transparency. He's currently pursuing arson charges against Zeminski. Explain, not to the court, explain to the people who are watching the strategic reasons for which Binger might have a vested interest in pursuing charges against Zeminski, which would make him potentially unavailable as a witness.
Here's what the prosecutor was hiding in this case. Zeminski, Zeminski's girlfriend, Rosenbaum, Huber, Jump Kick Man, and Yellow Pants Man were coordinating and conspiring and escalating criminal activity that night, which they sought to culminate in beating Kyle Rittenhouse to death. So how does the prosecutor keep that evidence from the jury? Well, what he does is He never identifies Yellow Pants Man, quite conveniently. He never identifies to the defense or to the court Jump Kick Man, though he knows who he is, allows criminal prosecutions to go forward against him for other unrelated to that night events. Once again, you have another criminal coming after Kyle, someone with, again, domestic violence, family-oriented violence. That's the kind of person he is. It's not a coincidence that that keeps showing up in all of these attackers that night. He prosecutes Zeminski's girlfriend and gets her sent off to jail for other issues, which makes it very difficult to subpoena her for trial. He indicts Zeminski on arson charges and then deliberately delays the trial until after Kyle's trial so that nothing can happen there. With Huber and Rosenbaum, they're both dead, but he works great to keep out any evidence of their criminal past. But most importantly, by keeping out the other witnesses, he keeps out the criminal conspiracy that was taking place that night. Because if people understood what you had were sociopaths engaging in elevated levels of violence, escalated levels of violence, they were trying, okay, let's see what we get away with here. Can we take another step? Can we take another step? Can we take another step? So it starts with just some verbal threats. Then it escalates to playing around with some physical property in the streets. Then it goes up to pepper spray and gassing people. Then it steps up to starting to set little fires. Then it steps up to, hey, let's put a fire in a dumpster and run it into a car, a gas station, into police, something else. And then what was the next step? The next step was beating the daylights out of somebody they didn't like that night, and particularly some innocent looking kid like Kyle. And that's the significance of Yellow Pants Man pointing him out earlier. That's what's really taking place that night. That's where Rosenbaum's threats to him matter. It's all coming together, and the prosecutor hit it all by manipulating the prosecutorial process about available witnesses so that they wouldn't be available at trial. Oh, you're on mute.
I just brought up my own comment saying that you're blackpilling me right now, and you just did with that. Gosh darn it, it drives me nuts that I don't see these things because I'm not sufficiently blackpilled. But when Yellow Pants Man says, you pointed that gun at me, knowing that he probably did, or he said the green laser, because I don't think actually anyone ever said gun, but maybe I'm mistaken. And now the way you describe it there, that is fabricating the provocation in order to justify the response. First of all, no, he didn't. And he wasn't on a roof, so clearly he didn't, even if the lasers were associated with the guns. But you accuse someone of that type of provocation to then, in your own mind and in the mind of the mob or the group, justify a response that's the guy that just pointed a gun at me because somebody just said it, and therefore you get to escalate everything. And the way you describe it, yeah,
They're trying to build it, and that's why the Zeminskis are ready right away. They threaten Kyle. Kyle's shocked, drops the fire extinguisher. Then they had Rosenbaum ready, and again, as the testimony and video showed, so Kyle's coming down the street, and Rosenbaum runs past him and runs to the right and hides behind two cars. It's not a coincidence that right nearby is Zeminski and his girlfriend. The girlfriend's turning, waiting for Kyle, so that when Kyle comes by the van, sees Zeminski, Zeminski shows him the gun, and clearly, whatever you believe about Kyle's testimony, says something threatening, because all you have to do is watch Kyle's reaction. He drops the fire extinguisher right away and tries to start stepping back. So it was a real intense threat. At which point, Rosenbaum has now come out from behind the cars, ready to chase him down. And further back in the crowd includes Yellow Pants Man and Jump Kick Man and Anthony Huber. And remember, as Kyle's taken off, it's not a coincidence that Zeminski then puts the gun up in the air to fire it up in the air as game on. And that's what Kyle realizes as he comes back around, and all of a sudden people are screaming, get the boy, cranium. And who's yelling the most? Zeminski's girlfriend. Get him, get him, get him. He just shot somebody, just shot somebody. Other people screaming him. You see Yellow Pants Man saying things. You see Jump Kick Man coming after him. You see Anthony Huber coming after him. And Gabe Grosskreutz, again, associated with a lot of these groups politically, radical, communist, revolutionary, violent organizations with his own long, extensive criminal history, of course, engaging in the same chase. And that's the goal, is to lynch somebody that night. And if you've studied the history of public lynchings, This is how they happen. There's a group of people there. If you study what happened in Tulsa, you'll find small groups of people inflaming finding select events to inflame public opinion, get a mob created, create a crazier and crazier rumor or story, so that everybody feels justified in the madness of the mob lynching, and that's
and
what they
Robert,
wanted to do.
and you know what I mean. And if you had no video evidence, if you didn't have the forensic evidence that you have here, video evidence, you'd have and if it went down the way they wanted it to, you'd have a dead Rittenhouse beaten to death because he pointed a gun at someone, and no one would. There would be no evidence to contradict that narrative. I just want to bring this one up because it's a good question. Why is Zeminski only charged with arson and not possessing and or discharging a firearm? I
Or
presume,
disorderly
Robert.
conduct, criminal trespass, property damage, threats. So some people had asked who else could have been charged that night. Zeminski, in my view, could be charged with conspiracy to commit murder, because I think that's exactly what he and his girlfriend were doing. I think Grosskreutz could also be charged with that. And I think and Jump Kick Man could be charged with that. I think all of them, and maybe Yellow Pants Man as well, because I have reason to believe, based on evidence that's already been developed and other evidence that I'm aware of, that this was a criminal conspiracy to kill the kid. And it fits, again, the sort of riotous public lynching mindset. And it's the mindset that goes in and kills David Dorn in St. Louis. It's the mindset that beats people in front for the world to see. I mean, a man in Kenosha had been beat badly just 2 nights before, a furniture store guy. So, I mean, people forget what had happened in some of the summer of love that summer, but people were being beaten in the street. And if you weren't able to defend yourself, I mean, in Portland, they went behind a guy and shot him right in the head. So, I mean, this was the mindset. This was that group. These are people who politically justify their criminal sociopathology as part of some communist revolution and all that nonsense. But that they are committed to this set of aggressive tactics. And Kyle was going to be a target that night as soon as they spotted him. And then once he was separated from everybody, it was game on. And that's what Zeminski's real firing was. But those other people, I agree with good logic, and not Nate the lawyer on this. There was no. Here's the thing: anybody who questions the McMichaels having grounds to arrest Arbery cannot tell me credibly that they believe anybody that night had credible grounds under Wisconsin law to claim they could arrest Kyle. So none of those people that attacked him, not Grosskreutz, not Huber, not Jump Kick Man, none of those three had witnessed personally what had taken place. So they didn't have probable cause at all from personal eyewitness testimony to arrest him at all. So, in fact, you haven't even heard the prosecution even try to make that argument. And because it's not the case, they all of them could have been criminally prosecuted if they had been successful in hurting Kyle and stayed alive. Huber and Rosenbaum absolutely could have been criminally prosecuted, and Grosskreutz could have, Jump Kick Man could have, both the Zeminskis could have, and anyone else, potentially Yellow Pants Man, who was complicit that night. The prosecutor went out of his way not to do so, while structuring other independent, unrelated charges to keep them from being available witnesses for the defense.
Robert, this is a black pill delivered through a suppository. Let me just I'm going to bring this back up. Fact and Suspicion podcast. I don't agree with necessarily the modern leftist, but I'm going to read it because I appreciate hustle, and I've seen you. This is probably the best advertisement $20 can buy you. Modern leftists only want criminal justice reform when they like the defendant. Brought to you by Viva's future favorite podcast. I will tell you in the future if, let me bring it back up, Fact and Suspicion podcast becomes my favorite podcast, but I am always looking for good information, so I will check it out. This is not an endorsement. That was just reading a super chat because I like the hustle. It's not.
They believe in street theater. They believe in owning the streets and violence. They misinterpreted the Tea Party. Occupy was infiltrated in this manner. Breitbart and Bannon both documented at the time in their own documentaries that there was a part of Occupy. I don't agree with them that all of Occupy was corrupt. I think there was a legitimate part of Occupy Wall Street, but there was definitely a part of Occupy Wall Street, as Tim Pool documented, that was completely fraudulent, that was meant to instigate violence. And the reason why the Occupy Wall Street fell apart was because these groups are these are criminal sociopaths looking for an excuse, whether it's the Klan, whether it's radical Islamic terrorism, whether it's anything you might dig in and think it's based on political beliefs or religious beliefs or racial beliefs. It's not. There's a reason they're recruited in prison overwhelmingly. It's because they're criminal sociopaths who are just given an excuse to say the cause demands you do this. The country demands you do this. God demands you do this. And like, oh, I get to act out on my criminal sociopathology. That's why you dig into the Klan, 80% of them had histories of domestic violence and the like, right? That's who they were, the violent members of the Klan. Not a coincidence here. You have the exact same pattern with the Zeminskis, with Jump Kick Man, with Grosskreutz, with Huber, with Rosenbaum. Violent assaults or attempted assaults on their own family. That's who these people are, and that is why the prosecutors had to keep that hidden from the jury, and that's what a lot of this misconduct was about. And then they had to go further. They had to make sure that the owners of CarSource didn't show that Kyle was legitimately present there when he was, by suborning their perjury, and doing so by selectively not investigating or subpoenaing other criminal activities that they may be accused of, or creating extended or expanded civil liability for them. That's why you had to intimidate the photographer witness into trying to changing his testimony to conform to what they wanted. So, I mean, that's why he's engaged in it. And then he went further with Kyle in front of the jury because he was afraid that he would lose the case in front of the jury, and he knew down deep this judge, unless you really pushed him hard, won't do anything about misconduct in his courtroom because that's your typical judge. And you have to just scream bloody murder before they pay attention. And I think the defense made the mistake, in my view, of I mean, they seem to suggest that they would get better rulings from the defense, from the court, by not raising issues of prosecutorial misconduct. I think it's backfired on them, is what's happened.
I mean, I brought up a chat that said, the defense has not laid out that theory of the case that you just laid out about the ambush. And I mean, it's not a no-brainer. It's just Occam's razor. I mean, it's what you see with your own eyes, and it may not be true. It might have just been totally random, but it's 100% on. And we've talked about it before, the political permission slip. I don't know enough about the history of the KKK to know, that they recruited criminals, that they recruited in prisons. I don't know that. I just know what I see in real time here. That was it a coincidence or was it by design that the three individuals involved in this, Zeminski seems to have a criminal history. Now we're learning Jump Kick Man seems to have a criminal history. I doubt they recruited Rosenbaum, but the event certainly attracted.
They just did it in live time, the way criminals like this operate. And what it was is, I think, what they could have done, because the court allowed them to do it, but they didn't do a good job of it with the defense during trial. And I wasn't going to raise it before trial because I was hoping that they would raise it without, tipping anybody off. But now the trial's over, can lay this out in detail. Is that once the judge said you can introduce any of the evidence about any of these individuals that happened earlier in the night, as long as it happened during the night, it's all free game. That was a great opportunity, because if you dig into the video footage, and it's obviously clear now the defense had not fully vetted the video footage, didn't have as many video experts as they told me that they did, because they're unprepared, constantly let in a lot of illicit hearsay, prejudicial hearsay, unlawful, non-expert, expert opinion, etc., which we've detailed before, so I won't recount that here. But if you watch the video footage throughout the night, these guys are at the center constantly of the escalating violence, and that they're in the same physical proximity of each other all night long, escalating the violence, escalating the conflict. So it wouldn't take a genius to tie those stories together to show how the video evidence proves that theory of the case. And then the jury realizes this isn't even a political case anymore. This is about a group of sickos who infiltrated a civil rights march so they could commit criminal sociopathic violence under the guise of a civil rights march against this little kid. And then you could convert a lot more people. It's also just the reality of what actually happened, and it explains things much better than the prosecutor's fictional fairyland version of events.
And actually, I took the note where Grosskreutz, before pulling his weapon, but he didn't point it at Kyle, so it's not that scary because Kyle had a big gun. Before he did that, he was, if his intent was to stop an active shooter, someone had asked, why was he running down the street with him, interviewing him, asking him what he just did? Why not end it? Why, if that's his goal, why not do it there? Instead, running down, what did you just do? What just happened? And then only later on pull a gun in an attempt to neutralize what he thought was an active shooter. What bothers
And the
me?
goal was, I think, for him, he wanted to get a confession right there so that it would justify him shooting him. That, hey, look, everybody on Facebook, ooh, he just admitted it. I had to take down this active shooter and be the hero that night. That I think is what he was up to.
It bothers me because, first of all, I think you're right. Not that you're right that bothers me. It bothers me that I don't put these things together. You're 100% right. This story was not told. And at the very least, people watching it now are going to see what could have been by way of defense, but also what is by way of circumstance. That it's interesting. They didn't recruit Rosenbaum, but he showed up because of his because of who he is, and they see him there and say, this guy is one we can use right now. Because someone's screaming, shoot me N-word with the hard R and not the A. And I'm not saying that to be glib. This is a guy who's clear at a BLM doing that. It's a no-brainer. But they see this unhinged individual, and instead of calling him out and saying, dude, this is a BLM protest, no, they then weaponize him, and they then, between all of them, the way you describe it now, and I do see them working like a pack of wolves trying to take down a deer, and that deer was Kyle Rittenhouse, except that deer was armed and, but for the grace of God, escaped with his own life, because I don't know how it happened. Now that I've seen everything, I don't know how Kyle Rittenhouse made it out alive. He was 2 blocks away from surrendering when incident 2, 3, and 4 happened. And but for missing a bicep, because I doubt he was aiming at a bicep, he would be dead. But for missing Jump Kick Man, well, no, he didn't survive because of that. But but for not getting him in the right spot of the head with the skateboard being used like an axe and not like a skateboard, he'd be dead. The way you describe it now, it is a pack of wolves hunting down a deer where they think they are politically empowered to do so. And but for the video evidence and the survival, the story gets told, but it didn't get told the way you said it got told during the trial. But yeah, that's let's go to the chat and see if that's a black pill moment for a lot of people here, or a red pill followed by a white pill. Hopefully the jury gets it right, and hopefully justice is served.
And I still think it's an 8-4, 8 or more jurors want to fully acquit Kyle. So it's just about the jurors who got on the jury who were not honest but in their jury selection process. Were not honest about their abilities to put aside their prejudices. Now, to be frank, that's the norm. The most prejudiced juror is a juror who cannot see their prejudice. I'll take a juror who tells me, yeah, I've got real strong biases on this case. I've taken jurors like that. One of them became a foreman in a jury of mine that became a very good foreman. The jury deliberations were longer than the trial because he wanted to make sure the evidence was really tested. And because he was aware of his bias. But most people are not aware of their biases. So it's ridiculous in jury selection when you say, hey, can you put aside your prejudice? Oh, of course I can. Hogwash. You need to ask meaningful jury selection. You need to do meaningful jury selection, or you run this risk and you put a kid like Kyle unnecessarily at risk. But I still think the outcome is going to be acquittals, maybe a mistrial. The risk for mistrial keeps going up the longer the jury deliberates. But I'm still hopeful that acquittals come back because the facts were still so compelling and so convincing that that's the only thing logic and law could result in.
Let me just read this. I'm on track to graduate with a BS, which is a Bachelor in Science and not bull poo-poo, in cybersecurity soon. Watching the Rittenhouse trials, tech-based chicanery. Oh, I'm not wearing the chicanery. I'm wearing the anti-media. Was painful. Makes me wonder if I should continue college to get a JD. I hope this encourages people to get law degrees for good and not for bad. Can he appeal if it gets it wrong, Robert?
He has many appellate issues. So he's got the issues in terms of both of the mistrial issues and the denial of those mistrial issues to date. But the judge, doesn't give denials. The judge is just not granting the request. So that's why he's holding it in abeyance, hopefully hoping that he will only need to employ it. Really, I think he's hoping only need to employ it if there's a mistrial, a hung jury. I don't know if he has the courage. I hope he does, but I don't know if he does if there's any convictions that come back. But plenty of appellate issues. Both the mistrial issues are appealable. The jury instruction is appealable. The misconduct is independently appealable. Now, it's harder to appeal all the defense screw-ups, but it's not impossible to appeal. There are two ways you can appeal that. You can appeal it as plain error through the appellate process itself. You can also bring it as a collateral challenge as a habeas petition in state or federal court as well. Ultimately, goes to both levels. The appeals process. Unique. In criminal cases, you actually get 2 bites at the apple if it's a state prosecution, because you have federal habeas rights as well. It means somebody's wrongfully being detained is all habeas petition means. And only Lincoln actually tried to suspend that, unfortunately. Not one of his wiser or brighter moments. But yes, he has many robust appeals. And the Wisconsin Appeals Court is a mixed court. Wisconsin Supreme Court, which would not have to take the case but could, will likely be a 5-2 conservative court by the time Kyle's appeal got there. And that's why the court of public opinion matters so much. And it's important in the court of public opinion because people are witnessing with this judge what a lot of judges recognize but aren't as honest as this judge is. Every judge I've ever met is influenced by the court of public opinion, but usually they hide it. This judge is honest. He's really forthcoming at how it impacts him. That's true for every judge. And that's
Robert,
where, in the court of public opinion matters. And that's why it's important that people continue to advocate and point out the truth for Kyle in that context, in case there's some runaway verdict.
I love the fact that you say a second bite at the apple and not a second kick at the cat, which I still haven't checked the etymology. I will never believe that the expression was ever 2 kicks at the cat, but like as if when you want to kick a cat away the first time, it doesn't work, so that it comes back and you kick it a second time. It came from a kid's game of kicking a can. But Dark Crypto is trying to get to you both. I will message him. I don't know what it's about, people, and there's no promises, but I'll definitely message him because I think we're connected on the Twitterverse. What was I about to say? No, hold on, Robert. There was one more that I wanted to get to, which was a question for Barnes. Here. Question for Barnes from Tails. Have you ever seen a case where the prosecution has been so close to triggering a mistrial so many times in such a prominent case?
Oh, yes.
Okay. So
it's not new at all. That's commonplace.
And this is the funny thing is like we're all seeing it. By the way, this is not an endorsement because I understand now on Twitter, apparently, if you endorse Kyle, you can get your tweets removed. Thank you, WP Zai, for the super chat. Robert, what was I just about to say? I just lost my train of thought. Have you ever seen? Oh, yes,
high profile cases.
Yes. Well, and the funny thing is, I said it, during the stream today with Ricada. We're all seeing this, and it's shocking because it's the first time we've ever seen it. This is the first really high-profile case in a while where we're seeing it. I presume, Robert, I have no direct experience, but I'm just going to make an assumption based on the 100% success rate of corruption in a high-profile case. This happens all the time, and you take even lower level, less politicized, less interesting cases. This just happens through and through, and we're just seeing it. And now we're just going to make the wrong conclusion that this only happens in high-profile cases. This case is only high profile because the general public made it high profile. I presume this happens all the time. Yeah. Tell me I'm wrong, but I know I'm not.
Usually worse in lower profile cases. It always, in every political case I've ever had. Now I know for like Emily Baker, state prosecutor, longstanding California, for her, she's shocked by this. And that's because your old school, ethical, run-of-the-mill, straightforward, completely apolitical case, those cases are much less common that you see it. It's in a lot of the cases that I'm involved with, the only reason they're there is because of corruption at some level of the process, whether it's the judge, whether it's the prosecutor, whether it's the law enforcement agent, whether it's some politician that demanded it go forward. At some level, corruption took place. And it doesn't mean like quid pro quo monetary corruption. It just means somebody not following the ethical duties to do justice and only comply with the rules, the constitutional rules and legal rules that apply to criminal investigations and prosecutions. And the same with a good number of civil cases that I handle. I mean, they're almost all of my cases are political. It's pretty rare they're not. I mean, it's just the nature of my practice. And so I witness it a lot more often, probably, than most defense lawyers, and have studied the long history of them. So I've been studying criminal cases of this kind going back 200 years. Patrick Henry defended one of the first great political cases. Though his victory, he made it more political maybe than the prosecution did, but the whole goal was to really wipe out tobacco farmers unless they, conceded to the state entirely. And, his give me liberty or give me death. And only that was back when juries could control sentencing and only issued $1. The lowest possible fine was what the remedy was there. But cases have always been political. The play Chicago, which has been made into a movie many times over, it's all about the political nature of court cases. It's inescapable. It's inevitable. And it's a popular subject of film and Broadway and books and TV series for that precise reason. And once you experience it enough, it's you're ready for it, you're prepared for it, you understand it, and you have to prepare for it, and you have to figure out strategically how you're going to address it, how you're going to go at it, so on and so forth. And I think the defense here just hasn't done the job they could have done and should have done, because the resources were made available for them to do this.
Well, Robert,
if you're going to block everybody and say everybody else out, by golly, you better deliver, and they did not.
one thing is clear. They did not do the job that you quite clearly could have done, because you're saying things now. This is not, well, it's not wizardry. It might be wizardry of intellect, but this is not stuff that they did. And we know it because they didn't do it. You're saying it, and you are maybe the first person to say it, but you're definitely saying it, and it was not done. So they could have done it, but they didn't. Why not? Who knows? Serious question. Does R. Barnes ever sleep? And bringing up my boomer moment, Robert, I never realized I could adjust your mic on my end. I mean, holy crab apples. How's the audio now, people? Now I know I can adjust both my it's only been 2 years, Robert. Okay. No, it's terrible, because it's not to play Monday morning quarterback, backseat driver, whatever it is. These are not even things that I would have ever thought of. And these are things that clearly you have already thought of, which were made available. And it's not a question of glory hogging. It's just a question of the pursuit of justice.
Yeah.
So
I mean, I was more than willing to let them take all of the credit. And but what I was not willing to do was stay silent when they refused to allow anyone to help. And I mean anyone. I mean, Andrew Branca, law of self-defense, he was willing to consult on the case. I'm the one who reached out to him. I said he needed to be a critical consultant on this process all the way through, help prep for opening statements, closing arguments, thematic strategies, legal issues. The guy wrote literally the book Law of Self-Defense.
well, and I was gonna just stop you to let you know, everyone know who was watching Ricada today. Andrew, what's his first name? It's Branca's last name. Andrew Branca, Branca, who literally is LSOD, law, LOSD, law of self-defense. It's got a channel. Seems to be a very successful,
the leading book on the law of self-defense.
And
Titled The Law of Self-Defense.
I'm not saying this as though success is the indicator of authority, or that authority, sorry, is the indicator. Which way do I mean this? I'm not saying this as though his success is an indication of his authority. His authority is defined by his success, because obviously you don't get good at what you're doing if you're not good at what you're doing. He's gotten good at what he's doing, and I did not know that, Robert, until you mentioned it now.
It's almost all he's done for 25 years. I mean, this is, as he points out, it's not practical for an individual criminal defense lawyer to focus on law of self-defense, because it's maybe 1 or 2 cases a year. So, and usually smaller scale cases, and usually not clean self-defense arguments. So when you got somebody that's all he does, consult on just the use of force and law of self-defense, and you refuse to use them, you refuse to listen to them, I'm sorry, that's not doing your job. And again, if you're going to do that, okay, but by golly, you better perform. And they didn't. I mean, and now we're seeing the consequences. And hopefully, the jury still comes to their senses, and the facts are still overwhelming enough that we get acquittals. But the kid's now at risk. And I think what you saw today was some panic by the defense that, holy cow, this is not going. And I have reason to believe that David Hancock, at least, thought this would be a no-brainer case and just wouldn't listen to the idea that, hey, all David Hancock cared about was money, 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 money. And I kept saying, we need to focus on the kid winning. I said, I only care about the kid winning. And so the quid pro quo was, I'll help you raise money. You help me help the kid win, and make sure that doesn't get shut out. And then they did shut it out after they raised the money and pocketed it. And now they put the kid at risk. And so it's just inexcusable.
That might be an audio bite to clip so that people can know what's going on here. And I want to bring this one up. Will be miffed. That's the joke. But do they get to seek defamation damages later only if Kyle gets a full acquittal? Can they also seek defamation damages when a mistrial with prejudice happens? Defense seeking money later. So, Robert, let me see if my knowledge of American law is good. Conviction, no defamation. Just
Right.
So I think that goes without saying. The mistrial without prejudice, I do wonder, would that preclude any meaningful defamation against anybody?
Preclude it, no, because it's the same as a legal acquittal. Mistrial with a prejudice, any dismissal with prejudice is in law in Wisconsin and around the country legal acquittal, because this came up in the Amy Cooper case. That dismissal was with prejudice, no diversion, with prejudice. That means it's legally equal to an acquittal.
Okay. It's strange to see BLM and the left advocate for such prosecutorial tactics that they argue unjustly incarcerates a disproportionate number of minorities. Well, no one accused those entities of being morally or politically consistent.
I mean, to their credit, some have. Glenn Greenwald has been very consistent about his criticism of this case. So has Alan Dershowitz.
Yeah, well, I'm sure a few of them are, but Glenn Greenwald is public. Greenwald is public enemy number one as well with the left now, so as is Dershowitz. It's like the second you call it out, you're public enemy number one. But it is very funny, just coming back to this, the idea of showing voter ID is racist, and yet vaccination passports are not. It's what happens when you have no principles. Is you have no principles and you have no consistency in your ideologies at any point in time. It's not because you believe them vigorously on one issue and then contradict them vigorously on another that they still make sense. No morals equals no morals, but that's a separate issue. Do you think the defense team is watching this? I sure hope so. One thing's for certain, spread this so far and wide they can't ignore it. It's not a question. Do not solicit, do not harass. Spread it so far and wide it becomes unavoidable, not just for the defense team, not just for Kyle Rittenhouse, not just for Wendy Rittenhouse, but for the world at large, and for, I would say, I presume the jury members are not watching this, so they won't see this.
It's educational and informative for people in future circumstances. If you face like circumstances in the future, learn from these experiences so that you become better equipped. Self-education is the first step to self-empowerment. And that's the whole reason this channel exists, is to give that opportunity. Well, the show exists. I shouldn't speak.
Don't worry, Robert. I'm not sensitive like that. You're right. The reason why this took off, the reason why this entity took off, my channel, but not just my channel, the lawverse as a whole, is because it's so. I was going to say knowledge is power, and it's a cliche.
It is. So you can't get. There's a reason why most dictators kept people illiterate for as long as they could. It's because self-education is critical to self-empowerment. The more you know, the more power you have. Because at the end of the day, the system can't exist without your compliance with it. If you're able to meaningfully and intelligently and informatively push back, you change the power equation entirely. And never underestimate your own ability or capacity to change the world. Your self-education matters. Every person who is more self-educated is more self-empowered, and that changes the entire balance of power. And that's the only way the balance of power has ever changed in the history of the world.
And I'm going to tell you this. I didn't hear what you just said for the last 10 seconds, Robert, but I can imagine what you said because I think I know what you said nonetheless. Someone sent me this. Let me just make sure I get it here. There can be no tyrants where there are no slaves. Jose Rizal, who is a Filipino, I don't want to say revolutionary, but very well known. And I said, and it was funny, I had it in the background. I said I was going to put it up on the wall, but I wasn't convinced I agreed with it. And now if I can abstract from the top level view is, okay, no tyrants, no slaves, no tyrants, fine. But typically, nobody makes themselves a slave voluntarily, and tyrants make slaves. So I wasn't sure I agreed with it, but now I understand the deeper meaning that ignorance creates the slave of sorts, and which is what the tyrants want to do. And it's a beautiful way you have of phrasing it. By the way, who I know who sent me that shirt. Thank you very much, by the way. But it's a beautiful thing. It's a yes. It's illiteracy in another era, and then it's social media and media illiteracy in the modern era. And be media illiterate and think that the PolitiFact fact check is truth. You are effectively illiterate, but not in the sense that you can't read words on a page. You can't understand facts and lies on a page, which is a very different type of literacy, but literacy nonetheless. Holy cows. Where do we go from here, Robert? What were the other... Hold on. What were the other issues? I took some notes down here. Oh, the drone footage. Oh, my goodness. Thank goodness I take notes because I have no memory anymore. The drone footage, Robert. What's the deal? Let's start with the dropping off of the file of the drone with the prosecution. Do you know details on how they acquired that drone footage in the first place?
So it was made. I was made aware last summer that on Tucker Carlson, some video drone footage had been shown that led the defense team to believe there must be FBI drone footage. And that's what, and my understanding was that the defense team and Mark Richards put on the record today that they had located who Tucker identified who it was and the name of the company. The thing was that company had disappeared. I mean, within 2 weeks after the incident, that company vanished.
If I can stop you there. 2 weeks, they disappeared 2 weeks of the event occurring, or 2 weeks of the footage being delivered?
2 weeks after the event occurred. So
Okay.
their footage gets aired a couple of days after the incident on Tucker Carlson. The name of the company and the individual who takes credit for that footage is listed on it. But then when you try to find who that company is, the company had dissolved 2 weeks after August 2020. So they tracked down who the individual purported to be. The investigator talked to him and they said, "Oh no, we that's not our footage. That's some sort of mistake." Now the defense, I guess, my understanding was the defense followed up from there. It's not apparent. They told me that they did. I don't know whether they did or they didn't. But what happened is that drone footage, to my knowledge, John Pierce never had that drone footage. The defense never had it. So there's no chance. I mean, unless David Hancock had it and he somehow is connected to this, to my knowledge, nobody had it on the defense team. I know Mark Richards didn't have it. And so then they finally disclosed that there is FBI drone footage, but it's a little bit different than what was shown on Tucker. And then the question was, well, where's the HD version of the FBI footage? The prosecution was late in disclosing the existence of the FBI drone footage, and then the FBI claimed, we lost the HD version. We don't know where it happened.
That's laughably implausible. I just want to say that laughably implausible. You have to. Let me be more direct. You have to be an idiot to believe that, and the only idiots in a non-judgmental way, but you just believe what CNN says, would be CNN viewers. It's laughably implausible. It's not just implausible in the sense that it happened. It's difficult to make that happen because most people think they've deleted things successfully, and they never have. And as lawyers, we know that. But sorry,
exactly.
Carry on.
And then, so middle of the trial, somebody walks into the prosecutor's office and says they have some video footage, but they wish to remain anonymous. Prosecutors get that footage and then want to introduce it into evidence. They share what they claim is their only copy of the footage with the defense. The defense kind of objects, but doesn't object as fully as they should have because there was no foundation for this. You don't get to drop off anonymously some footage and claim it's an authentic representation, accurate representation of the events. You don't know how it's been edited. You don't know anything about that. And so, in my view, they should have objected on foundation grounds, but the defense has waived every objection to foundation throughout this entire trial on video evidence, and leading to all kinds of adverse evidentiary effects for Kyle. Then but they did object to the lateness of it. Then it comes out during the charging conference when they're wanting the provocation instruction. They say they're going to rely on this footage. The defense puts in their footage, and the problem is it's very blurry. And the prosecutor, Krause, Sauer Krause, as I like to call him, puts out, he says, "Oh, we have a better copy of that."
Yeah.
And all of a
Who?
sudden, the defense lawyers like Wisco, who's an associate of Mark Richards, says, "Hold on a second." She did, by the way, a very good job today laying this out for the court. Said, "Hold on a second. What do you mean? This is the only copy we have. What do you mean you have a better version?" And it came out later that night and over the weekend that the HD high definition resolution of the video had never been produced or provided to the defense. That added to the Monday motion to dismiss with prejudice, and was the sole basis for the motion for mistrial without prejudice this afternoon, because the concern was this video, which they never got to see during trial, didn't get to prepare for, didn't get to have their own expert testimony to impeach or to refute or to rebut or to utilize in their own benefit, is now being highlighted by the jury, and the jury's wanting to see it on a big screen in the courtroom, and which led to the mistrial motion. But so it's another example, and their excuse was not a credible excuse. Their excuse was, oh, somehow it just magically condensed, and they only got the condensed non HD version. It must be because they have an Android phone, Your Honor. That was not a credible explanation.
Robert, what at the risk of crashing the stream? Hold on, I think someone just said it right here. I was going to ask. Here we go. At the this guy, I don't know who you are, but I noticed you. I only brought up the one that did not have the insult that was in a previous comment. Handbrake. Robert, do you know what handbrake is?
Here's another thing I've never seen before. When I present digital evidence into trial, I actually use an expert. I'd recommended that for them in this case too, for the defense. You bring in, I work with a guy who's great. Jacques is fantastic. He does fantastic work. He, done it for many of my cases. I mean, just brilliant. He just moves like this. There are no hitches. There are no technological glitches or delays. It's just boom, 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 because he's a professional. All he does is take evidence, put it in video presentation. He can also help you with opening statement, closing argument, putting the video together, etc. But he's like a paralegal, and he can do it for both sides, so that you can make sure it's competent, capable, and there's no contamination. Like, if my guy had been used for this case, the prosecution likely would have gone along with him because he's so much better than anybody they have. You know what he would have found? He would have said, "Hey, Barnes, there's an HD version of this that the prosecution has." He would have found it right away. That's the problem with not being tech savvy in the courtroom. And so they didn't they didn't have that aspect. But the other reason you do that is so you don't use your own laptop to broadcast evidence to the jury, because then it's broadcast to the world.
Yep.
Which is what the nitwit prosecutors did. So you can see their screen, you can see how they organize their exhibits, and included on his state exhibit screen were actually two different, Handbrake was one, I forget the name of the other, two different apps whose sole goal is to do the kind of thing that he claimed he wasn't involved in this case.
Okay, and I'm going to tell you one thing. I know on my personal laptop, I have nothing that would be incriminating. I have one client file on the screen that, even though that's still public information, I would not want people knowing that. I don't want people drawing the connection. This dude, I mean, it was Krause's computer where he didn't think it through in any sense. But the question is, Robert, so the internet is the infinite knowledge of God, and God in the lower G sense, not the capital G. They are just, you got a million people out there, and they will confer, and they will dig, and they will get the truth. So it's a form of godness. People are pulling it up. How do you get it to the judge? Does it get to the judge? Does it get to the defense team? How do you get the people who need to know right now? Because they're living in a bubble. They're living in a vacuum. How do you get
broadcasting it? Because Richard's closing argument was much better than it likely would have otherwise been. Whatever its faults or weaknesses or limitations, it was still very, very good for Richards. That's just a different standard. But is because of all the collective effort over the weekend in the court of public opinion, that stuff got to people. So people think I have direct access. I do not. I've been shut out entirely. But anyone else can get that information. And if someone like Jack Posobiec shares it, if people like that share it, chances are the defense team is going to get it. I mean, Jack has 1.5 million followers.
I didn't know that. I mean, I didn't fully appreciate that. I knew Jack is big. Jack puts out the good information. Jack has sources that he does not divulge or disclose, and he's been very good. 1.5 million
He publicly
followers.
confirmed, like people were saying I was making stuff up about the jury. Jack publicly confirmed the exact same thing, that he is independently hearing from his independent sources connected to the courthouse the exact same thing that I was reporting about the jury.
So
It's you know.
here's a good question, Das Goose, and I'll tell you my layperson interpretation. Then Barnes will give me the actual answer. Das Goose says, "What does the prosecution gain by lying about the HD footage from the drone? I can't see anything from it to favor them, and I've flown drones for the military for 12 years." So here's the thing: I've flown drones now for, I would say, close to a decade. No, it's not a decade. 5 years. I've flown every drone from the Phantom 1 to the Phantom whatever with the Spark, and what they gained by this is that they took an HD. They had an HD. They had the actual, just a higher quality version of the video. They communicated to the defense a lower quality video, which they then submitted as evidence, sought to enhance, which brings you back to square one, but plus crap, and then said this proves provocation, where the original HD version, from what we've seen, doesn't really seem to prove that. But they created the ambiguity through the crappiness of the video footage, which resulted from the lower quality, then enhancing it to the higher quality. That's the only.
I mean, that was the advantage was twofold. One was their ability to manipulate the lower quality footage to claim something that what didn't exist in the higher quality footage, but also it allowed them, denied the defense the utility of the higher quality footage during the trial that they of things that would have helped them. So it was both. They could manipulate the video footage easier if they didn't disclose the high definition version to the defense or the higher quality version to the defense, and they could preclude the defense from spotlighting or highlighting during trial evidence that would have been favorable to the defense from the higher quality version.
And now I'm going to bring this up, not because I want to encourage the idea that I didn't bring it up on the alleged first 2 times. I didn't see it. Stephen Oglesby says, third time maybe, in a new trial, can Kyle ditch Hancock and get a new legal team? I mean, I know the answer, but Robert.
That's a no-brainer. That's an absolute. Whatever doubts may have been present are now resolved. Hopefully again he gets acquittals and he can just move on. But the warnings that I made and that others made about this team all came to fruition during trial and were independently confirmed by a wide range of people separate from me. You can watch the Rekieta live streams daily and see a wide range of lawyers from across the spectrum keep saying how bad this is by the defense. Mistake after mistake after mistake after mistake after mistake.
And the thing is this, like on Rekieta's stream, I would say it's unanimous. And I would say it's unanimous not to prove the authority, but to prove the objectivity. Because between Legal Bites, Alita, between Legal Mindset, Andrew, between Joe Neerman, Good Logic, Eric Hunley, who's not a lawyer, but has a great channel, check him out. Between Uncivil Law, Kurt, you had Andrew, oh my God, I forgot his last name. Bronca, Andrew Bronca. You had Hogg's Law, HOEG. You had Nate Brody.
Lawyer.
Everybody is in agreement, and they are of all walks of life, politically speaking. So at this point, it's objective, period. The only thing that makes it subjective is what your financial and media interests are, and which is why you see fact checks confirming garbage crap facts and mainstream media promoting garbage facts narratives. It's subjective, and then you realize that people just don't even know certain basic facts of the case. 2 weeks after the trial, they don't know because the media doesn't report it, and then they have the big tech oligarchs, censoring or soft censoring. You can still make a video about it. It won't be monetizable, and we won't promote it because it's not monetized. And that's the circle jerk of economy for big tech. Oh, it's not monetized? Well, why would we promote it? Because we're not going to make money off of it. So we demonetize that which we don't like so that we don't have to promote that which we don't like. It's the circle jerk of political economics. I like that. Too big for a shirt. But that's it. And so you see people now, not knowing because of this, but a lot of people discovering it despite that.
Yeah, no doubt about it. And it's there for people to see. Anybody that's continuing to defend the defense team is just sticking their head in the sand or is part of the defense, of the Hancock or related defense team. There's no objective definite. Not a single lawyer on that panel or any lawyer that I know would ever recommend either of these lawyers, but definitely not Richards, ever be hired as lead counsel for any kind of case. That's just from what they've witnessed. That's the reality of it. Definitely not for Kyle's case.
I thought that was a middle finger, but it's an actual pointing up. So that's a good sign. And the other one, not such a good sign. My kid burnt his middle finger on a glue gun yesterday, and he's like, I got hurt here, but it was that's my ring finger. Just my ring is there. The only footage that is 100% forensically sound is that in the raw file format MP3 movie it's set are all already compressed and have lost important data. True, but there's losing important data and there's losing critical data. During the stream today, and God bless the community that Ricada has, people put up the low res image and the high res image and then zoomed in on a spot to show the difference. I mean, it's the difference between seeing handles on doors of cars versus not seeing individual humans because they've gone full Back to the Future, dissolved into future. So it's amazing, but this is why I'm thoroughly convinced the powers that be do not want the aggregate knowledge of the internet inspecting and scrutinizing the biggest decisions of government and the police.
No doubt about it.
Has anyone reached out to?
I did, but he was stepping back until the trial, and he'll continue to step back for a while. But I mean, I get that. Yes, I think the senator at some point needs to be involved.
And I just want to bring this up because, Like a Boss, I love this cup. It was a Father's Day present. Lonely Island, people. Like a Boss is one of the greatest songs.
I used to have a sweatshirt that said that.
Was it Lonely Island or before Lonely Island, Robert? That's the question.
I have no idea. I didn't know it had any correlation to Lonely Island. I don't know what that is.
Okay. As he sips from his InfoWars mug, yes, that shows our Robert, you're 44 years old, correct?
How old?
44?
47.
40. Okay, so a little bit. So we're generationally separated. Lonely Island is the greatest fake rap band of all time. It's Andy Samberg and the boys from SNL.
I recognize Samberg.
No, and I'm not. I was saying that tongue in cheek.
He sings "I'm on a boat."
Yeah, that's right.
I'm on a boat, right?
That is a surprisingly inappropriate song for a kid. Just so you all should know.
Yes.
Barnes, Barnes, do you want to answer this question?
I did. I represented Kyle from February of this year up until a week before trial, and was told that I could we would select a jury or would be heavily involved in it. Body language panel all agreed to help. A bunch of data people agreed to help. Several other jury consulting experts also agreed to help. It was a team of about 10 people. We'd also offered 10 or so people to help with the presentation of evidence at trial as well, including a wide range of experts across a wide range of relevant and pertinent areas. It was that first part had already been declined, but the agreement was we could have a major role in jury selection, and that was my focus because I believe this was a jury selection case. And then a week before trial, I was all of a sudden cut out entirely. And at the same time that I was asking questions about whether, in fact, the fundraising was actually going to Wendy Rittenhouse, as I had been told it was, because there had been a multi-million-dollar lawsuit filed that had received a copy of that alleged that was not happening, that, in fact, the money was being diverted to the control of David Hancock. And at that point, all of a sudden, I'm persona non grata and pushed out of the case. Kyle was made unavailable to talk. Wendy was made unavailable to talk. All of it. All of a sudden, a corporate law firm is involved that appears to have ties to David Hancock that's telling me they really represent Kyle. It's like there's a conflict there. I mean, it's a lot of shenanigans going on. And David Hancock has a lot of weird connections, weird, spooky connections. You can just look up David Hancock, Deep State Dave, stuff like that. And you'll find where people are documenting and detailing his very peculiar history and how he may be under criminal investigation for issues related to Puerto Rico. So that's who it is. The security guy controls everything related to the case because he controls the money. And you have a poor family, and he controls the family's physical security. So what do you think is going to happen? Well, this is not a family that knows the legal system, that's ever been through the legal system. And this is the guy that controls whether the grocery bill gets paid, whether one of the sisters' medical bills get paid. What do you think is going to happen? The guy's hijacked complete control over the family and their life.
And I
did everything. I did all that work for free, spent money out of my own pocket, did 6 figures plus of legal work, never billed Kyle a penny, nickel, dime, or dollar. So this was not about money. I had agreed to take a step back. You know, the only thing I regret is now I would run roughshod. I would come in, make an appearance, force the issue, go whole hog. You have to be mean and vicious. I tend not to be in these situations. I want to work with people, try to let them, if figure out what's their objective, try to meet their objective while also meeting the client's objective. Find a way you can unite the two and not create unnecessary conflict. Unfortunately, in some of these cases, you can't.
Apparently the Rumble stream is down, and I got a notification through StreamYard, and I don't know. I don't think we broke anything on Rumble, but if we did, I'll take it as flattery. But Robert, I mean, that's what I want people to appreciate is your time, and not your time. This is one thing about lawyers. People hate lawyers because how dare they charge $500 an hour for all they're doing is thinking. And I've never charged $250 an hour in my life, Canadian. But how dare a lawyer charge $500 an hour when all they're doing is just sharing their thoughts? It's knowledge acquired through decades of experience and refined knowledge. And when you say you value your time at 6 digits, and I have, Robert, I can evaluate our live stream times. It's a very easy, calculatable sort of function. Whatever your hourly rate is, however many streams we've done, everyone out there on the internet, that's your aggregate knowledge value of what you get from these streams, because it is what you get. It's 6 figures without a question. And I know you're relatively selfless in the sense that you're relatively selfless. And I know things that I don't discuss publicly, but when people ask these questions, and I'm glad you answered the question, it's not stuff that was withheld for personal gain, personal profit, or personal what's the word I'm looking for?
Not of any kind. If I wanted to be a grifter, if I wanted to make money, I would be a quiet tax lawyer and write my own checks until the day is long. Don't need the public attention, don't need the ego validation, had plenty of big cases, all of that, and went to great lengths. And some people ask, why didn't I recognize it sooner? It's a reverse version of confession through projection. 2 reasons. One, I assume people are coming at this with good intentions that care about their client first and foremost. Unfortunately, you have to assume otherwise often these days, but I hate that mindset to have. But the second was I was directly assured that we would have a major role in jury selection all the way through. And I knew if we picked the jury, they could be the most incompetent rubes at trial, period. The facts were so overwhelming, we picked the right jury, it's going to be straight acquittals. People have now seen that in live time. That, despite all the mistakes of defense, everybody was pretty much convinced that came into this with any objective view that wasn't prejudiced against Kyle. Even some people who came in prejudiced against Kyle, David Packman, others, reversed their opinion substantively on the key charges in the case after witnessing the evidence. If you had any degree of openness toward the evidence itself was so overwhelming that there was, because, as you note, it was all videotaped. But even the state's own witnesses making critical admission after admission after admission in favor of Kyle on the stand, because that's what the facts are, that the only real risk here was jury selection. And I thought, as long as they gave me jury selection, I don't care about the rest. And they can even take credit for the jury selection. I won't say that we're doing it. I won't take a major public role in relationship to it. And then at the last minute, they pulled the rug out from under us. Maybe they never intended to do it. I don't know. I just know they unnecessarily put a kid at risk. And honestly, I never assume a lawyer will do that.
I'll say one thing now. I'm smarter than Robert in one respect. I never trust anybody. It took me a long time to even trust Robert. Or to assume that Robert was not. I don't know what I have to exploit in the world, but I'm skeptical of everybody without exception. Except my wife. She's proven to be the most trustworthy person on the face of the planet. Even my kids don't trust a thing they say. But Robert, I'm saying it tongue in cheek, is that you had your expectation of what you thought this was about, and you imposed that on others. It's confession through projection, but not in the self-condemning way. It's more like in the, I guess it's self-condemning. You were naively thinking everyone was as altruistic or looking out for the interests of others. That maybe they are. Maybe this all ends well. And
if it ends well, then I'm as happy as anybody. So and hopefully that still is the case. And again, I think there's still a very good chance that is the case. But it was just unnecessary to be here to take this kind of risk because of whatever was driving them. But and for other younger lawyers out there, learn from this as well. You'd never live in such a bubble, never have such a big ego that you don't take advice and don't welcome feedback and don't welcome ideas. There's always going to be people that have other ideas. It's the confrontation of ideas that often leads to the best ideas. That's part one. And I've been doing this a long time, and I always seek out opinions. I mean, when I'm thinking about a case, I talk to bartenders, I talk to waitresses, I talk to stewardesses, I talk to taxi cab drivers and Uber drivers. I talk to anybody about some aspect of it to see what are the feedbacks, what are the ideas. That's why I poll it extensively. That's why we do focus groups and mock trials. I mean, not like, don't do a long mock trial, do a short one so that actually gives you information, doesn't confuse or contort the case. Because you recognize in this business, there's no way you're going to have a perfect insight into the case. And so borrow from other people liberally, and don't get caught in associating it has to be done my way. It has to be any of those things. And again, you can be the final decision maker if that's what you want. I used to work with a lawyer who was always obsessed with being the HFMIC, and you can get, or HMFIC. That's actually it.
Hold on. HMFIC, the hot mother effer in charge.
Yeah, the head
never heard it in my never heard it in my life. By the way, that's my strength in life.
And I was always like, why do we got to do it that way? Let's just take everybody's feedback. Let's take care of everybody's advice. Let's let the best idea win. I mean, there's plenty of things that I would have other lawyers do in a case if the opportunity afforded me, because I'm skilled in some areas, not in other areas. So there are other people that would be better for particular witnesses, better clients, better certain cases, certain clients, certain adversaries, you name it. It's in my view, it's the devolution of the legal trade. There's always been ego. Ego's always been an issue. But look at how Johnny Cochran handled the OJ case. That is how you handle even huge ego defense lawyers. He did a brilliant, masterful job at putting everybody in the right place to maximize their skill set. He even kept F. Lee Bailey, who was infamously difficult to work with, directed and channeled. I mean, that's how. And why? Because Johnny only cared about winning for his client. Put that first, and everything else will come easy.
I want to bring up one which almost brought tears to my eyes, but it did actually. If anyone could see it, get the HD version. I'll drone ship to your place. I trust you two more than any person I don't personally know. I am a forever fan. Harmon Armin, thank you. And I was thinking, I said, there's nothing worse. There's no greater curse than not being trusted. And that only comes with having violated trust, because ordinarily your instinct is to trust. And when you violate a trust and you're no longer trusted, it's the greatest curse ever, because how long does it take to build up trust and a split second to lose it?
Yep.
And with that, I mean, like, Jesus, I mean, the prosecution, they are untrustworthy. They're liars. It's a foregone fact. And then the question is, why do you trust anything they ever say again in the trial? The judge has to be polite. He's got to be objective. The media is going to spin what they do the way they do. If the prosecution says it, they're government employees. They have to be, sincere and authentic and honest. But they are proven pathological liars. And they are quite clearly in the pursuit of and I said it before, it's not a prosecution when you disregard facts and evidence, it's a persecution. And they are clearly involved in a persecution of Rittenhouse. And just so nobody clips this out of context and says Viva was condoning what Rittenhouse did. The greatest tragedy of this entire thing is that Rittenhouse had to do what he did because the authorities did not do what they ought to have done. And they forced ordinary citizens, not just one or two, because even when I started this case, I thought Rittenhouse was one or two, maybe five, showed up with AR-15s. There were, Robert, am I wrong? Close to 100 people with AR-15s. I mean, at least we saw.
There were a lot of people with major guns there that night.
So we were led to believe this dude Rittenhouse, a crazy white supremacist lunatic who showed up to shoot black people, who ended up actually shooting 3 white people, one of which was a convicted pedophile. For anybody on the jury who's watching and shouldn't be.
He was defending minority, immigrant, women-owned businesses from destruction by people who were yelling the N-word at anybody they could that night.
I'm just waiting for someone, by the way, to meme a shoot me Binger, like shoot me Binger, and then put in Binger with his finger on the trigger, pointing at the jury. Meme that, people of the internet, like Rosenbaum saying "shoot me Binger," and then Binger with his finger on the trigger. This is who you're dealing with. You're dealing with Binger defending Rosenbaum. And the fact that he was a convicted pedophile was not known by Rittenhouse at the time. But according to Krauss, the theory of the case, if you're being attacked by a lunatic who's attacking a guy with a gun, your sole cause for self-defense is to drop the gun and go fisticuffs. And that's oh, by the way, Robert, the sometimes you just have to take a beating. And then you said, and I didn't even put it together, if anyone on that jury pool has been subject to domestic abuse, no gender, just anyone who's been beaten in their lives, might not agree with that.
Yeah.
How
anybody that's been bullied, anybody that's been threatened, it's not to people who've taken a beating, but people who've been bullied and threatened and did things they didn't want to do because of the threat of violence or force against them. So, I mean, that was, and again, I think the prosecution decided after watching juror reactions that their only chance was a mistrial to hold out, and they argued inflammatory evidence to their side of the aisle. And the mistake of the defense was not doing a jury selection that kept those people from being on the jury pool. And again, there were ways to do so, because it was about a third that were hardcore biased, and there was about a group of 17 questions we identified that would filter out pretty much all of them. Plus, when you have a week to do data dives before then, you can get all that information and intel. So and what I'm encouraging is whatever, it's not bad grapes about this case. It's educational to everybody out there. Learn how to do this. If you're a lawyer, if you're part of a case, learn the value of jury selection. Don't pretend your view of the case is going to be the jury's view of the case. Understand the value of polling beforehand. Understand the value of doing versions of mock trials, but limited focus groups. If you can't afford that, do it in your everyday life with everyday people as much and as often as possible, and do probing, meaningful jury selection. Learn about motivated reasoning. I mean, why do we have some of the body language people on? Why do we have some Scott Adams on? These people educate you about how people really think, including the key decision makers in your cases. And if you're going to be a better lawyer, if you're going to be, or just a better advocate in any part of your life, you need to learn these things and quit. Don't pretend, as Mark Richards did, that the jury will think about, or this judge did, that the jury will think like you do about the case.
And someone had just said, and let me just see if I can bring up that super chat. I don't know what IOLTA is, and I just hope it's not
in the States, it's interest on lawyer trust accounts.
Okay.
So there are separate accounts that you set up that are trust accounts that are monitored by the state, and that you can't take the money out except under specific circumstances. I had proposed that option, and it was turned down by David Hancock.
No comment, but derive your own conclusions based on the defense now proposing a mistrial without prejudice, which would be very lucrative in theory for certain interests. Does anyone agree that the judge needs to be more tech savvy? If he was, we wouldn't be. No, I actually, Robert, tell me if I'm wrong. The judge knows more than he's letting on that he knows. He knows more than the prosecution does, but the defense is not seizing on the implied knowledge of the judge to let the defense know that he knows the prosecution is lying. Am I wrong?
Partially. Almost all the judges, because of their generational standing, don't understand technology like we do, and definitely not the way younger people do. And so because of that, it's important to, now what most judges do is they delegate that. They have a tech staff, particularly in federal court, and they let the federal, and in federal court, none of this would have ever been allowed. And in most state courts, frankly, it would increasingly not be allowed. But in federal courts, none of this shit show, frankly, would ever come about. Because, in fact, before you're even allowed to introduce technological evidence, it has to clear a bunch of legal and evidentiary standards, but it also has to clear certain technical standards. You have to test it. You have to be trained in the court's technology. You have to work with the tech administrators. You have to make sure it's going to be flawless, and they get very agitated if it's not. But I mean, I've done cases in major state courts across the country, and at this point, they are as well, a little behind, but nowhere near where Kenosha is. But this judge was trying to upgrade the technological capabilities, and it's because they didn't have a tech-savvy expert there. That's a quarter of the problem. Another quarter of the problem was not litigating these issues prior to trial, so the judge was educated and informed about it. Another problem was not having a video expert there throughout the trial, multiple ones that could explain these things and translate them. When Richard says he doesn't understand these things, I have no doubt about that. When I first used the words AI to Richards, he asked me, "What in the world is AI?" So that gives you an idea of his tech savviness.
Well, I've got my own acronym, my reflexive answer for AI, and I have a dirty mind, so I'm not even going to say it publicly. But I'm sure the chat can. What did I mean by AI? We'll see.
It won't be as bad as Rekida's chat.
You know what? For the AI, I think it would be fitting for Rekida's chat. and speaking of the glory of Rekida's chat, it's glorious. I mean, you don't
it's
have
great
to.
to see him blow up. It's great to see people introduced to Andrew Branca, Law of Self-Defense. I highly recommend his book. It's very good, useful for people. He also knows the best self-defense associations where you can really get an equivalent of legal insurance for any risk you may face down the road. It's great to see the exposure for, Good Logic, Uncivil Law, Nate the Lawyer, Legal Bites, Legal Mindset. All of them have seen their channels really dramatically explode because Nick's channels exploded. Great idea of Nick to put meaningful legal commentary with an ongoing trial of high profile interest. That's incisive interest. That's not the incisive insight. That's not the kind you're going to get from conventional opinion. That, there's cross section. I was on Tuesday Night Tights with the Geeks and Gamers last night because this matters to everybody everywhere. This is about the core rights of self-defense in America, the core ability of you as an individual to protect your own liberty, to keep your body inviolate. We're seeing that in multiple contexts right now in the law. Do I own my own body or not? Can I protect my own body or not? Can I defend my own body or not? And I think this case strikes a deep chord. Also, you're seeing one of the most clear-cut cases of pure innocence put on trial for his life that you'll ever see in America. And so I think that's another reason for the interest. And credit to Nick for increasing public attention to this case, giving a platform for incisive insight so that people can get meaningfully self-informed, meaningfully self-educated, and thus self-empowered about the entire legal system. A lot of people on the right waking up. I was on with Michael Malice about this. I think he'll be up today or tomorrow about the importance of waking up about problems in our judiciary, problems with our prosecutors, problems with our police officials, that they're making questionable, problematic decisions that put the most innocent people imaginable at risk for the most moral and justifiable acts possible. And more people that wake up to this, the more they realize that they need to lobby the court of public opinion. Just as the election fortification, they use a different F word when I was growing up to describe this election, but election fortification woke up a lot of people to the problems in our election system. People are starting to wake up to the problems in our criminal justice system. And I think that's great for the long-term health of our public criminal justice system is more people involved, engaged to make reform and change to take place.
And I do not.
Nick Rekieta has helped do that substantially.
I gotta say, like, there's no. It's an amazing thing what Rekieta has done. The exposure he has given to other people who have been existing on the interwebs for a while, but have not gotten this level of exposure. It's a net positive, period, all around. Because now people are discovering new outlets, new sources of information for unadulterated, I guess is the word to say. It's amazing. I guess the question is this: while I choke on my own tongue, what do we expect tomorrow? What do we expect for the week? And where do we go from here?
So if you continue to have a jury conflict, and there's some concern that basically there's especially 3 to 4 women on the jury who were described by some journalists there as Karen-type personalities, mask wearers, people who came from, one of them may have been an older female professor, came from old Yankee ancestry, that if you understood the politics there, if anybody's from Chattanooga, it's like if they came from multiple families of Lookout Mountain. If you knew in Chattanooga and you got a class divide in a case, you know not to put someone from Lookout Mountain on that jury trial. Now, at least not from the Chattanooga part of Lookout Mountain. The Georgia part, there's some different folks there.
I'm gonna guess about 17,000 people right now have no idea what you're talking about.
I'm sure. So this is just the Chattanooga folks, but it's the same dynamic that there's 3 or 4 of them. One of them may even be the forewoman, and so what you would expect to see tomorrow, typically the way the way they've gone about things, they haven't asked questions, but it sounds like the leaders on the jury may be the ones pushing for conviction, but that the majority is for acquittals. If that is in fact the case, what you can anticipate tomorrow is more requests, either maybe if they're still conflicted, probably you'll start seeing some questions. And don't misinterpret the questions. The questions might sound like, oh man, those sound like conviction oriented questions, but it may be because the leaders on the jury are still a minority trying to force the others into their side, and they're the ones behind asking of the question. So the way it's progressed, first they asked for self-defense instructions, then they asked for all the jury instructions. Then they said they were going to look at some videos. Then they looked at a bunch of videos, including the drone footage. That sounds like a few jurors trying to argue to the other one, see why we're right, and that their arguments are not working. And the question is, how long do they hold out? How committed are they? How much do they badger everyone else into trying to change their mind? Are they willing to try to do a compromise verdict instead? Or do they capitulate? Because the thing with a lot of those authoritarian kind of personality types, and the defense had a misguided notion that those would be helpful jurors, which was wrong. And that was explained to them, but they may have put them on anyway. Is that they have difficulty being rejected by a majority of people. They like to believe that their opinions are not only the correct opinions, but that everybody reasonable shares them. And when people don't, they almost have a cognitive dissonance moment. And then they often capitulate and go home. But hopefully Kyle has some hardcore people committed to him no matter what, so they won't allow convictions to occur, won't allow compromise to occur. And then secondly, hopefully he has some hardcore people that are leaders for him. And if that's the case, then it'll go back and forth, and you may see a range of questions that may sound confusing throughout the day tomorrow and the next day if it's a holdout jury. If they do not have a verdict by end of business on Friday, you're likely looking at a likely hung jury. If they're going to come back with acquittals or a compromise verdict, that will likely happen later tomorrow or early Friday.
Okay, what I will love is that I looked at it the exact opposite way, that you have the majority trying to convince two holdouts to acquit. But I appreciate what you're saying right now is because someone has to take the jury for person, so I don't get
Because they
canceled.
pick that person before they vote. The first vote they make is the four-person vote.
That's amazing.
So they don't know what the four-person believes at the time they make them four-person.
But the
And if it's
person
an
most
old Yankee aristocrat who's used to running Kenosha for family from generations, if it is someone like that, that's the rumor. I don't know if it's true. Then they would fit. And if they're like an older female maternal professor type, the type of person that loved running around with COVID mania fear for the last year, telling you what to do, and oh my God, why isn't your kid with 3 masks? That kind of personality that hyperventilates when you get on the plane without a mask.
but stop it there. Apparently that video was totally fake, which I thought it was fake to begin with, but that video of the person freaking out about breathing oxygen of the person saying that, apparently that was fabricated. I don't know.
Oh, I'm sure that video was, but I'm referencing, I've seen that. I've seen people freak out. It's just insane. I've seen stewardesses freak out. Oh, you know, while you're sleeping, they grab your mask and stick it over your face, and it's like
someone touches my face when I'm sleeping. We're gonna have it'll be a bad incident, but I say that as a joke. I'm not a big man. Someone touches my face when I'm sleeping, I'll apologize for them touching my face. But Robert, so it's an interesting thing: is who is going to take the role of the jury foreperson? It's going to be someone who's proactive, someone who's ready to do it, which by and large would not be, if I'm wrong, would not be someone who's ready to acquit, but rather someone who's ready to convict and activist to begin with.
Yes, right. Exactly. And if they think they're leaders for the community, to the super chat question, their excuse may be fear of public reaction of full acquittals, but it's not their motivation. Their motivation is they came in presuming him guilty and believe their job is to lead the lynch mob. They don't want to see that as what they're doing, but it is in fact what they're doing. So it depends on the rightness and righteousness of the jurors who know Kyle is innocent to stand up for it and do their constitutional and perform their oath of their office, because that's what this is now as a juror, and acquit him as the law compels.
All right, we're going to end it with this because I think we've exhausted the discussion of the evening. I think Eric Hunley is going live with news with booze. No, is it booze with news or news with booze?
News with booze.
It's news with booze. Eric Hunley, people, was one of the
Unstructured
panelists.
podcast.
Unstructured. He's amazing. Robert, we will undoubtedly find ourselves on Rekieta at some point tomorrow. And may there be, I would say, good news. I
I'll
don't
be
want to
probably
say
on a little less. I got a lot of work tomorrow.
and that was the other question is, when do you sleep? When do you work? But we know you do both, because you do both, and you are not just a human, you are a superhuman as far as it goes in the legal world. So, Robert, I'll represent on Rekieta stream. Just message me what I have to say to look smart, and we'll be good. Everyone. So tonight, News with Booze. Eric is going live. I think now he's like 3 minutes into it. Tomorrow, I'll be on Rekieta. If I'm those kids are going back to school, whether they like it or not, and they're not sick. They just cough and sneeze. They're going back to school because Daddy needs to have a life and whatever. What do we expect? It's Thursday tomorrow, so what do we expect for the rest of the week? If there's no verdict one way or the other by Friday, we expect the judge to say hung verdict, hung jury.
I don't think he would. I think it would only be if the jury came back and say we're irreconcilably conflicted. And if it's the kind of jury foreman that I'm talking about, they might not say that. They might come back the next Monday.
Oh my goodness, can you imagine? By the way, I'm not going to say this to be cynical. There's not a snowball's chance in hell that these jury members are not reading, listening, or discussing the file right now. The snowball's chance in hell.
Well, the other thing is, I can't imagine them going through Thanksgiving. I can't imagine. There will either be mistrial or verdicts by next Wednesday.
When is American Thanksgiving? Because in
Next
Canada,
Thursday.
we have
a week from tomorrow.
Okay, fine. We agree.
I'll be back in the fine state of Tennessee for that.
I won't. Do I ask why? I shouldn't ask why. I don't know why. If I know that I shouldn't ask a question, I shouldn't ask it. Why, Robert?
Oh, for family for Thanksgiving.
Okay, fine.
I'll be at,
I thought it was quiet.
My nephew Sean is a really good cook. He's also a pastor most of the time, but a really good cook. So I make it back. And then my brother-in-law usually cooks some too, and he's a really good cook. So between both of them and catch up with the kids and everybody else. I got tons of nieces and nephews, all ages.
And we got the real Bambuga in with a joke. Hung jury. Wait, they're all dudes. I say there's a number of ways to. I don't like the term hung jury. Period. I don't like using it, which you might realize I don't use the term. I will say an undecided jury. But yeah, Robert. Okay, amazing. So we'll see what tomorrow holds. What do you expect for tomorrow in particular? Like what happens tomorrow?
I think if I'm right about things that it will probably go another day.
Ugh.
But I'm hoping for acquittals by Friday morning. That's what I'm hoping for.
All right, good. I'm going to end with this. Thanks, guys. Phenomenal. We are phenomenal, Robert. We not just that, you're phenomenal, and I suck off your phenomenalness to leech out a bit of my own phenomenalness. Okay, so vivabarneslaw.locals.com is where you can find us on Locals. Rumble is the other place. Here, Robert has been popping into Rekieta's stream, and just to give the other lawyers props, Robert, if I forget someone, let me know. You've got Legal Bites, Alita. Sorry, go for it.
I would say one addendum. Eric Hunley, Unstructured, I believe, is going to have the behavior panel on tomorrow. Oh, yeah. They were on recently on Dr. Phil, and people can listen to their advice and ask yourself, would I like those people to help me pick a jury? Would I like those people to help give me insights on a witness? Would I like those people to help me prep for a jury? That's what Mark Richards turned down. But more importantly, think about that for your future cases. If anybody out there knows a case, has a case, is a lawyer, is involved with it, this is the kind of expertise you should start to tap into, because these guys are fantastic. But you can see another interview with them with Eric Hunley tomorrow on his Unstructured show.
All right. And do it, because they are amazing. Hunley's amazing. Joe Neerman, Good Logic. Alita, Legal Bites. Andrew, Legal Mindset. Jesus. Hoag's Law. You've got Ian Runkle, who is also on the panel.
Runkle of the Bailey.
Runkle of the Bailey, but who else am I forgetting? I'm forgetting a ton of people right now.
There's a guy. There's a Matt. There's obviously Good Logic. Maybe you already mentioned him.
Yeah, on civil law.
Law.
The legal verse, the lawyer verse of YouTube is exponentially growing. But you'll see them and you'll decide who you want to follow and you'll decide who you want to listen to. But listen to everybody, because knowledge is power, even if you disregard it. So with that said, people, I'm gonna just close. News with Booze is live now. So when you leave here, there's a lot of people. Go check out News with Booze. Robert, stick around. We'll say our proper goodbyes. Everyone in the chat, thank you very much. I'm sorry I didn't get to all the super chats, but I appreciate it. And let's keep this momentum going. Sunlight is the greatest disinfectant, and we are shining a big, bright Robert Gruler. We are shining a big, bright spotlight of sunlight on the world. With that said, everyone, peace out.